if you've done any reading and research about human psychology and persuasion, you've surely come across the concept of anchoring. In this video, I'm going to tell you why attorneys need to be cognizant of anchoring when they engage the court of public opinion. Hi everyone, my name is Pollock. I am an attorney who helps other attorneys and their clients ethically, strategically, and proactively engage the court of public opinion to help those clients resolve their cases favorably and to help those attorneys build their practices. In this video, I want to talk to you briefly about the role of anchoring when you engage the court of public opinion on behalf of your client. Anchoring is the cognitive bias that says that when we as humans hear information about something the first time, that information tends to have a disproportionate effect on our decision-making and our perceptions of a given situation moving forward. A classic example of this is anytime there's a negotiation over price. The first number that's thrown out in any negotiation over price is likely to be the price or the number that the parties are going to be working off of. So for example, if you and I are engaging in a transaction to buy a car and I throw out $1,000 as the starting price or the starting negotiation price, that's very different than when you throw out $500. Suddenly, the starting point has changed. This happens often in the court of public opinion, but it's very subtle. It tends to happen more times than not in politics. You could surely recall when Obamacare was being debated, there was a Republican talking a point about death panels. And the Democrats had to not only fight back against the term and that nasty visual that death panels comes with, but also they had to explain what the actual groups of doctors or groups of administrators was going to do. They weren't going to sentence people to death. But by getting out to the court of public opinion first, Republicans framed the topic and framed the idea as death panels. And Democrats were forced to rebut that visual, rebut that language, and then on top of that, explain what those panels were. When you are an attorney representing a client who is either wanting to get publicity for a case or who has been the subject of bad publicity about a case, you must be cognizant of anchoring. And the way that you deal with anchoring is by framing the lawsuit and framing the legal dispute in the way that's most favorable to your client. Typically, plaintiffs' attorneys and prosecutors have a leg up here. They generally will dictate the news cycle of regarding a lawsuit or a case. Obviously, prosecutors and plaintiffs' attorneys typically tend to file the first document, the first court papers in a proceeding, and reporters and the media tend to repeat those allegations word for word when they report on the lawsuit. So when you're a plaintiff's attorney or you're a prosecutor, clearly the way that you frame the case in your court papers is going to have some legs and is going to often be the starting point for the defendants to have to rebut and fight back against. If you're a defense attorney, whether on the civil or criminal side, this is important for you to understand, anchoring and framing. What you need to do in a high-profile case involving your client is begin to turn the story around and reframe the alleged wrongdoing or reframe the entire legal dispute in a way that is more favorable to your client. And you see this sometimes. You see sometimes criminal defense attorneys will label prosecutions as overly aggressive or the attempt to criminalize what is purely commercial behavior. And you'll see civil defense attorneys sometimes attempt to reframe a litigation as a copyright troll or a patent troll seeking to badger law-abiding businesses. You'll see sometimes plaintiffs' attorneys being accused of filing frivolous lawsuits that are meritless. Those are attempts by civil defense attorneys to flip the script, if you will, and to try to reframe the case. You, as an attorney representing clients, need to be thinking how you can anchor and reframe, anchor the court of public opinion and anchor certain ideas in connection with your client's high-profile litigation or legal dispute as being covered in the media. You should be thinking about how you can constantly anchor and reframe the litigation or legal dispute to cast your client in the most favorable light. Because, and what's most important here, is the way that a lawsuit or legal dispute is framed from the get-go, anchoring, will tend to dictate how it's perceived for the length of the litigation, barring some kind of massive new information that comes to light or impactful information that comes to light that really does change the way litigation is perceived. Barring that kind of rare occurrence, attorneys need to be thinking about how to position and frame their legal disputes, their clients' legal disputes, so as to anchor the legal dispute in a certain way with the court of public opinion, who includes reporters, judges, opposing counsel, and arguably most importantly, potential jurors.